Hey everybody, welcome. News Now Wyoming, bringing you another episode. This time we're going to look at the first amended complaint between Mr. Johnson and the stupid cops, sheriffs. If you look at my previous video, Andre Roxx arrested for failure to ID, you can actually watch some of the video in relation to this case for more of a background. This one we are going to talk about the actual amended complaint here, and I'm going to point out the counts that have been dismissed with prejudice, meaning that they cannot be brought back again. They cannot be brought back up. So here we go. Mr. Johnson, or Andre Roxx, versus stupid deputies. All right. Hereby sues sheriff and deputy. This is an action for damages and injunctive relief brought pursuant to 1983, which is the Civil Rights Law, which authorizes actions to redress the deprivation under color of state law of rights, privileges, and immunities secured to plaintiff by the Constitution and the laws of the United States. And it authorizes the award of costs and attorney fees. State law claims are also set forth pursuant to this court's concurrent and supplemental jurisdiction. He has satisfied all conditions precedent to bring in this action, including all pre-suit requirements of Florida statute. I don't know what pre-suit requirements are required, but apparently they did it. And in the reply that we will also be going over, they don't argue that they didn't. So they tried to comply with this law to no avail. Written intent to initiate litigation were submitted to defendant sheriff pursuant to the law, and more than 6 months have passed. So apparently you cannot sue in Florida until 6 months have passed. If you, again, I'm reading into this. Basically that says you've got to give the sheriff or the person you are suing a chance to remedy the situation. So the parties, Mr. Johnson was in Pasco County. Defendants, we won't talk about them because they're just stupid cops. Statement of facts. An African American male was a passenger in a motor vehicle being driven on the road in Pasco County, Florida by plaintiff's father, an African American male. Does that matter in this case? I would argue with you, no. They do this to white people too. So color doesn't matter, but okay, I guess. The motor vehicle was towing a motorcycle on a trailer. Deputy Dunn undertook a pretextual stop of the motor vehicle driven by his father, apparently claiming he could not see the license plates on the trailer. However, as he walked up to the vehicle, he was able to call in the license plate for the trailer and the vehicle on his radio. So he's saying it wasn't completely visible, but he was able to get it anyway. Okay, do you lose probable cause at that point? Probably not, because he could probably ask the driver to correct the plate, right? It's just to fix it, make it where I can see it while you're driving. Simple request. Come on. Passenger was seated in the passenger seat and was not operating the motor vehicle anytime relevant to this matter. And this is an important distinction. If somebody else is pulled over, especially for the license plate being visible, do you have any reason to suspect that the passenger is the reason you could not see that license plate? Any reason to suspect that? It's pure stupidity. All right. At least 2 other deputies were involved in the stop of the motor vehicle. In addition, there was a film crew from A&E Live PD accompanying the deputies. I wonder if that actually got released. I'd be interested to know if this was actually part of an episode. If so, let me know. Deputy Dunn approached the passenger side of the vehicle where plaintiff was seated and requested the driver's license of the driver and the registration documents for the vehicle. He also asked plaintiff if he had his ID on him too. The plaintiff advised the stupid cop deputy that he was merely a passenger and was not required to identify himself, which is correct. We looked at the state law in the previous video, didn't we? We pulled up the state law, so not incorrect statement. Deputy Dunn told plaintiff that under Florida law he was required to identify himself, and that if he did not identify himself, he would pull him out and he would go to jail for resisting. He repeated the claims of Deputy Dunn and stated to plaintiff, "You gotta ID yourself." He then stated to the driver, "Listen, you can tell us who he is. We can do it that way." The father then identified plaintiff as his son and provided his name to the stupid deputies. So they already ID'd him. Now they just want to be jackasses and continue with just being jackasses for the reason that they are jackasses and they can get away with it. And they know they can get away with it. They are still employed by the sheriff's office, so they know that they can get away with this. At that time, they became aware of his identity as a result of his father identifying him by name. He then approached the passenger side of the vehicle, and Deputy Dunn stated to Deputy Penny he didn't want to give me his ID and all that, but his dad gave him up. The stupid deputies then stepped back from the vehicle, and Deputy Ramos contacted a supervisor via telephone. Deputy Dunn entered information into the computer on his vehicle. When plaintiff stated that he was not required to identify himself, stupid deputy said that's not true. Deputy subsequently walked back to the passenger side of the vehicle and then asked Deputy Penny if he minded doing a sniff with the dog. Deputy Penny asked Dunn if he wanted to pull him out, referring to extracting plaintiff violently from the vehicle. Then he told Deputy Penny to explain that and see if plaintiff would voluntarily exit the vehicle, and if not, then they would pull him out. Then stated to plaintiff and the other individuals in the vehicle that his dog was going to be conducting a narcotic sniff of the vehicle, and that plaintiff, his father, and the other passenger were required to exit the vehicle, which is true. Again, when we looked at the video, this was 8 minutes into the stop. So running a dog sniff around the car is not too inconvenient according to the courts within 8 minutes. That seems particularly fast, and I can't imagine any court would rule that this was unlawful based off of a case law. Now, saying whether or not they had a reason for it, that's questionable, but they can do this, and they did it. Specifically, he instructed them they had to exit the vehicle, stating, "I'm not asking you to, I'm telling you at this point." Then plaintiff stated that he would step out of the vehicle, and you hear that very clearly in the vehicle. As plaintiff began to exit the vehicle, holding his telephone in his hand, Deputy Dunn stated to Deputy Penny, "I'm going to take him no matter what because he's resisting me." Oh, so he was voluntarily stepping out. There wasn't resisting in any way. Resisting arrest is, anyway. All right. Stupid cops. Pull your heads out of your asses. Deputy Dunn then told plaintiff to put his hands behind his back, which plaintiff did. They then sought to place plaintiff in handcuffs and take plaintiff's personal property. He responded by asking if he was under arrest, stating that he had a Fourth Amendment right to maintain his property. After the plaintiff was handcuffed, they grabbed his pinky finger and twisted it away from the rest of his hand in order to force plaintiff to release his wallet. Plaintiff inquired as to why Deputies Penny and Dunn were doing what they were doing, and Deputy Dunn stated that plaintiff was under arrest for resisting without violence. Deputy Dunn stated that by plaintiff not giving his name when it was demanded, he was resisting arrest. Imagine that. Oh, stupid cops. That is not what the courts have ruled. Deputy Dunn then conducted a pat-down search of plaintiff and placed him in the back of the sheriff's vehicle. Although there was no legitimate basis for the search, nor for further delaying his father, then they brought a dog to sniff the outside of the vehicle. Again, I disagree with that. They did that in a relatively quick manner. Case law is going to say that that was justified. Deputy Penny claimed that the dog was alerted on the passenger side door. While he was in the rear, the vehicle proceeded to search his wallet, took his identification, and entered plaintiff's information into a computer located in his vehicle. Now, this would be a search in relation to the arrest, and therefore, again, according to the courts, this would be a valid search because it's pursuant to the arrest. At the same time, Deputy Ramos was speaking with plaintiff's father and the other passenger. He stated to his father, "We do it with everyone, okay? We have to identify. It's an officer safety type thing, but it's also a matter of, for all we know, I'm not saying that he is. He could be a convicted murderer out on whatever, We have to identify. Okay, I'm not going to read the rest of his stupid crap here. Deputy Ramos was aware that the decision of Deputy Dunn to stop the vehicle in which plaintiff was traveling was motivated by plaintiff and his father's race, because Deputy Ramos stated unprompted to plaintiff's father and the other passengers, "I can honestly tell you the Pasco County area is predominantly white. We have a very actual good relationship with the Hispanic community and the black community. I'm Hispanic myself. I don't ever really have any issues with anybody but white people, so I apologize." That's not him. During this conversation, he also stated, "We like to pull people over," and bragged about the fact that the interaction was being filmed by the television program Live PD. Plaintiff's father again provided plaintiff's name to Deputy Ramos, even going so far to ensure that the spelling of plaintiff's first name was correct, and provided plaintiff's date of birth. And again, at this point, they already have his identification because they searched his wallet. During this time, Deputy Penny was searching the car based upon the pretext of the claimed actions of the dog, but did not find any drugs in the car. And this is the problem with drug sniffing dogs. Police dogs can have a 30% accuracy rate, and they are still allowed to be in service. They can fail 70%, they can fail 100% of the time, and still be a good pretext. Completely bullshit, and dogs should not be allowed. Canine dogs should not be allowed to provide pretext for a search. They should not be able to provide probable cause. Courts disagree with me. One day that will change, I hope, because this is completely BS. I got his ID out of his wallet. Provided a Miranda warning to plaintiff, and plaintiff advised him that he was invoking his right to remain silent. Then he subsequently stated to his father that the reason why plaintiff was going to jail was, in the state of Florida, all occupants of the vehicle are required to give us name. They have to identify themselves, so they don't have to physically produce an identification, but they got to at least ID themselves, and we got to be able to ID who's in the car. That's by law. So with him doing that, it's obstruction. The reason we say resisting arrest, it's the same statute. It covers the same thing. Bullshit! Okay, Deputy Dunn also stated, I'm going to do my job, and if anyone prevents me from doing my job, I'm going to take them to jail. I understand he was trying to exercise his rights there and everything, but we have our rights to do our job. You have no right. Okay. Plaintiff was taken to the Pasco County Jail and booked on a charge alleging violation of Florida Statute 84302, resisting, obstructing without violence. He was held in jail during the evening and required to post a bond to be released. He was charged in Pasco County with the violation, and shortly after the incident, defendant's sheriff's office stated to the Tampa Bay Times that it had reviewed the arrest, found that the deputies acted appropriately. So here, the sheriff's office is saying that they did everything by the book, and we approve of everything that they just did. He also ratified the arrest of plaintiff because the supervisor informed Deputy Dunn that he should arrest plaintiff. In addition, all of defendant sheriff's deputies involved in this arrest, Deputies Dunn, Ramos, and Penny, stated to plaintiff or his family members that he could be arrested under these circumstances for resisting arrest without violence. They have a pattern or practice of failure to train his officers in the requirement to arrest someone for resisting without violence. He has created a constitutional policing advisor, the stated role of which is to guide defendant sheriff through and making recommendations on issues related to accountability and adherence to best practices, policies, and procedures, blah, blah, blah. So they're doing, the sheriff, that paragraph right there is saying that the sheriff is trying to do the best he can to advise the cops on how to behave, and that they found that this was appropriate. And further ratification of the unconstitutional nature of this arrest, defendant constitutional right policing advisor, ignoring basic constitutional law concept, opined that plaintiff was lawfully detained during the traffic stop, was lawfully required to provide his ID, and was lawfully arrested for resisting arrest without violence for refusing to do so. Then, of course, the judge dismisses the charges because, well, yeah, why wouldn't you? On or about November 26th, they denied the state's motion for reconsideration. So the prosecutor was like, no, please, judge, please let us prosecute this guy. And the judge said, no, you're stupid. In fact, we'll take a look at those exhibits because I've already paid for them, so we may as well look them over. Criminal case was resolved in plaintiff's favor, and the state did not appeal the dismissal. Clearly established law. At the time of plaintiff's arrest, the law was clearly established that a law enforcement officer could not arrest an individual for failure to ID himself if the request for identification was not reasonably related to the circumstances justifying the stop. In Brown v. Texas, a unanimous Supreme Court held that the guarantees of the Fourth Amendment do not allow law enforcement to stop and demand identification from an individual without any specific basis for believing that he is involved in criminal activity. And being in a passenger car by itself is not being involved in a criminal activity. If you pull over a car that's been stolen, that would be being involved in a criminal activity. If you watch a car pull up somewhere, shoot somebody, and drive away, that would be being involved in a criminal activity. Pulling somebody over for a traffic citation does not mean that everybody in the passenger in the car is guilty of that driving infraction. In 2004, the Supreme Court categorically reaffirmed that an officer may not arrest a suspect for failure to identify himself if the request for identification is not reasonably related to the circumstances justifying the stop. Again, this is a traffic stop. Similarly, the 11th Circuit recently reiterated that it was clearly established prior to the arrest of the issue in this case that under the Fourth Amendment, an official can address questions to a person at any time, and the person is free to ignore his interrogator and walk away. U.S. v. Mendenhall. However, an official may conduct a brief investigatory stop, otherwise known as a Terry stop, if he has a reasonable suspicion of criminal activity. Though reasonable suspicion is a less demanding standard than probable cause, the Fourth Amendment nonetheless requires a minimum level of objective justification for an official to make a Terry stop. This objective justification must exist at the onset of the stop. Objective justification does not exist based on a mere refusal to cooperate with the official. In addition, at the time of plaintiff's arrest, any reasonable officer would have known that probable cause for an arrest under 84302 statute could not be based on mere words. So this is Olson versus Stewart. At the time of Mrs. Olson's December 12, 2012 arrest, any reasonable officer would have known that probable cause for a violation could not be based on mere words. So you cannot resist an officer with mere words. Florida courts have generally held, with very limited exceptions, that physical conduct must accompany an offensive words to support a conviction under 84302. So I've highlighted the ones that have been thrown out, so we don't even bother reading them, besides possibly just, but I don't read the whole thing, okay? So count one, not thrown out. Fourth Amendment violation of false arrest. Plaintiff realleges paragraphs 1 through 71 above, and that he violated his rights under the Fourth Amendment to the Constitution. These violations were the type and character as to which any unreasonable person would be aware. They further violated constitutional and civil rights as protected by the Civil Rights 1983. Deputy Dunn acted in bad faith and with malicious purpose, and in a manner exhibiting wanton and willful disregard of human rights, safety, and property. Deputy Dunn misused his power possessed by virtue of state law and made possible only because he was clothed with the authority of state law. The violation of his rights, as described above, is actionable under 1983. Foregoing actions of Deputy Dunn were willful, wanton, and in reckless disregard of his rights, and were taken without any justification or in the absence of probable cause. The defendant knew or should have known that there was no probable cause to arrest, imprison, and or place plaintiff in confinement, as described more fully above, given the circumstances present and the clearly established law and the proof needed to establish probable cause. Based upon the facts presented to Deputy Dunn and the applicable law, no reasonable law enforcement officer could have concluded that there existed any probable cause to arrest the plaintiff. The law was well settled and clearly established that the actions of Deputy Dunn constituted the false arrest under the Fourth Amendment to the United States Constitution. Deputy Dunn was acting under the color of law, so we're just going to keep repeating. As a direct or approximate cause of his actions, he has been damaged. Mental anguish, pain, and suffering, loss of capacity for the enjoyment of life, embarrassment, humiliation, loss of reputation, and the loss of other emoluments. And count number 2, also not thrown out. Fourth Amendment against defendant sheriff. So this is going to say the same thing as above, except this is saying that the sheriff endorses these acts of his officers. And we see that in the paragraphs above where they're saying the officer, the deputy sheriff is not actually stopping his officers, and he supports their actions. So that's what this count is going to allege against the stupid deputy or sheriff. Okay, so count 3 was tossed out. Common law negligent training. This was tossed, and so this is just saying that you were negligent in your training. Again, tossed. Count 4, tossed. Common law negligent supervision. This was tossed. Common law malicious prosecution against Deputy Dunn. This is the contempt of cop, right? This count sets forth a claim against Deputy Dunn for the malicious prosecution and is pled in the alternative. For the purposes of this count, Deputy Dunn was acting outside the course and scope of employment with defendant sheriff. He filed false charges against plaintiff by misstating the applicable law by asserting that plaintiff was required to ID himself to law enforcement. He also fabricated evidence in his report detailing the arrest, which was submitted to the state attorney for the purpose of instituting a criminal action against plaintiff. Specifically, he falsely claimed that plaintiff prevented his father from providing law enforcement with his name. We see very clearly in the video that after his father provided the name, he said, "What the hell, Dad?" Right? Something like, that's not a direct quote, but that's the intent. But he did not stop him from using it. But even if he did, oh well. Not a violation of law. The above described actions by Deputy Dunn caused a commencement and or continuation of criminal proceedings against plaintiff. Proceedings had bona fide terminations in plaintiff's favor, and the charges against him were dismissed. There was no probable cause or reasonable belief. So again, this was, they're calling it malicious prosecution. I call it contempt of cop. Count 6 was dismissed, intentional infliction of emotional distress. Wow, intentional infliction of emotional distress. Again, this was tossed. Count 7, battery. Wasn't a violent arrest, except for the twisting of the pinky, I guess is what he's saying, to get him to cause harm. Yeah. Battery against the defendant sheriff. And this was not tossed. Is that right? Hold on. Oh, nope, this was tossed as well. I was like, no, that doesn't make any sense. How can you have battery against the sheriff but not the person who was there on scene? Okay, count 9, not dismissed. False imprisonment and arrest. I think we've covered that pretty well. Count 10, common law false imprisonment against the stupid sheriff. And demand for trial by jury. Demand for attorney's fees. Court grant equitable relief against defendants under the applicable count set forth above, mandating the defendant's obedience to the laws enumerated herein, providing other equitable relief to plaintiff, enter judgment against defendants and for plaintiffs, awarding damages, enter judgment against defendants and for plaintiff, permanently enjoining defendants from future violations. That's not going to be passed. Enter judgment against defendants and for plaintiff, awarding plaintiff attorney's fees and costs, grant any other further relief as just and proper under the circumstances. So now we are going to go ahead and take a look Okay, we are at 25 minutes, so I kind of want to do this quick. Exhibit number 1. Oh, nope, that's the stupid logo. Okay. Exhibit 2. This cause having come before the court upon defendant's motion to dismiss on November 9th, 2018. Based upon the court's review of the defendant's motion to dismiss and the Straits Traverse controlling authority, and after review and consideration of all other appropriate matters presented, the court hereby grants the defendant's motion to dismiss. Then again, the prosecutors went back and said, please let us charge him. And so this is that motion denying that. I said, this is the motion. Okay. All right. This cause or order denying the state's motion for reconsideration. The cause having come before the court upon the state's motion for reconsideration, it is therefore ordered and judged that the state's motion for reconsideration is denied. 21st day of November. So I think that's only like it's 2 weeks later. He denied the reconsideration. Doesn't give any reasons for it other than what is in this original. And we could look at some of this case law, but really I don't care about this part. We'll see exactly what happens in the federal lawsuit because it's going to cover all of these things already. So there we go, you guys. Here's the first actual court document video on the Andre Roxx false arrest for failure to ID. Let me know what you guys think. Were the cops in the right? Are they those counts that were dismissed? Should they have been dismissed or should they have stuck in there? What do you think is a good result of this lawsuit? This was this is number 25, and there are now 51 items in the docket, so there are plenty of other things to review here. I do want to look at the motion to dismiss. I want to go through that in the next video, and then possibly one of these orders where he actually dismissed some of the charges. So I want to show people exactly what that looks like. So this is a great case for that. Let me know what you guys think. Make sure you hit like and subscribe, and thank you, and have a great day.